Homeowners who want to renovate must often get permission from a city board. Krummenacher versus City of Minnetonka concerns what happened when a city granted a public television host permission to renovate a garage, and her next-door neighbor protested that the city had applied the rules too flexibly. JoAnne Liebeler owned a house in Minnetonka, Minnesota. On the property was an old, detached, flat-roofed garage that had been constructed by a previous owner back in the 1940s. This old garage was set back 17 feet from the front yard lot line. After the garage was constructed, the city passed an ordinance requiring structures to be at least 50 feet from a property's boundary line. Because the garage was built before this ordinance was passed, it was considered a permissible nonconformity. The garage roof leaked, and the old structure needed repairs. Liebeler decided that, while she was fixing the garage, she might as well add a yoga studio and craft room on top. She'd maintain the same footprint. Because adding this addition would result in a vertical expansion of a non-conforming structure, Liebeler applied for a variance. Liebeler's neighbor, Beat Krummenacher, protested, complaining that the addition would block his view to the east. Liebeler and Krummenacher both presented their cases to the City Planning Commission at a public hearing. The commission concluded that denying Liebeler the variance would cause her undue hardship, that it was a unique circumstance, that her proposed addition would comply with the spirit of the ordinance, and that it would be within the existing character of the neighborhood. It granted the variance. The Minnetonka City Council affirmed. Krummenacher sued the city, challenging its finding of undue hardship. He argued that a municipality should only grant a variance if the property couldn't be put to any reasonable use without it. He claimed that Liebeler could put her garage to a reasonable use as a storage space for vehicles. The trial court affirmed the variance, and Krummenacher appealed to the Minnesota Supreme Court. He argued that the city hadn't applied the correct standard to determine whether Liebeler would suffer undue hardship if she weren't granted the variance.